Okay, so I don't know whether it's you or whether it's me, but we've been going very slowly this year. So I realized this morning, talking with Lance, that I wouldn't finish what I wanted to do with you today. So we've agreed, and I'm sorry, this is the bad news, you're going to have me for another 2 sessions. So that we can just take our time and finish the constitutional aspect, which I think will take up at least 1.5 sessions, if not more, and then finish with a session or half a session on property law, real property, and what we call personal property, in other words, immovables and movables, and the trust, just so you've got a very brief picture of some fundamentals of English civil law. So I'll be here next week and the week after, and we'll be in this room. Okay? And then you will start with Lance in the, not quite sure when actually, but then you'll start the contracts and torts. And you'll have a section on criminal law with Dr. Ganshar, who's coming over from Essex in the next semester. So we were talking about European law last week. And it may be helpful just to talk about the impacts on the English system, very briefly. There have been a number of significant impacts on our system. Probably the first one to mention is constitutional, and we'll look at that in a minute. And then there have been a number of impacts on our substantive law, and you can look particularly at employment law. Another aspect is the applicable law to contractual obligations. That's the so-called Rome regulation on the law applicable to contractual obligations, and that is something that is extremely important in practice. It's something that I come across in my activities every week. The reality is that most business people don't choose the law that applies to their contracts. It's has to be determined by the law. The second aspect is procedural, or the third aspect is procedural. There is what's called the Brussels regulation on the question of jurisdiction of courts and the enforcement of judgments. Yet another impact, and this is a sort of mixed constitutional and procedural impact, is the effect that European law has had on our, what we call judicial review process, which you will remember is the way the courts control decision-making powers of authorities. Another impact is the impact on the system of precedent. think we talked about that already. Just to remind you, and it's quite technical, the Court of Appeal, you will remember, is normally bound by its own decisions, so that it can't change its own case law or precedents itself, with some very limited exceptions. And it would seem, I say would because this has been discussed in a case in the Supreme Court, so it's perhaps not a definitive position, but it would seem that the Supreme Court considers that in exceptional cases, the Court of Appeal could change its case law to take account of subsequent decisions of the European Court of Human Rights. And this has come out in particular in relation to what are called the assisted suicide cases. It's the question of whether a person who assists someone to commit suicide can be liable to prosecution for a criminal offence. But there are other examples, such as the right to privacy. And the last impact, which I think we have already mentioned, is the impact on the method of interpretation used by the UK courts to interpret UK legislation which has implemented European directives. Just to summarize that particular section, or this particular section, we started by looking at substantive aspects, and I mentioned employment, working time. There is at the moment a complex debate in the UK about just how much European law there is in our legal system. And of course, the Eurosceptics are trying to say that our legal system has been completely taken over by Brussels, which is of course it's just a complete exaggeration. And then the government has produced various statistics. There have been committees of the House of Commons and the House of Lords that have been looking at this. It's actually quite difficult to quantify in a statistical manner. In reality, it's probably impossible to generalize, because certain areas of our law, like the civil law, probably have only limited changes caused by European law. But then if you take consumer contracts, for example, or if you take food regulation, you will find that European law constitutes a very significant part of those particular fields of our legal system, just as they do in France and all the other European countries. So I don't want to, and it's not the scope of this course, to try and sort of develop a profile of the degree to which European law has invested our legal system. What you need to know is that there have been significant impacts in many areas, but I wouldn't go as far as trying to quantify that in any particular way. Looked at around the other way, has the common law system contributed to European law? And the answer there is yes, and in many ways quite positively. I just noted down a few contributions of English law to the EU system. The first is that there is a continual and useful dialogue between the judges of the Supreme Court, the UK Supreme Court, and the European Court of Justice in Luxembourg and the Court of Human Rights in Strasbourg. There have been tensions, and there still are tensions, but what the English judges are saying is that this dialogue is very fruitful, and it's continuing. And in fact, that dialogue doesn't stop at the European Court. There is a dialogue that's going on between all the top constitutional courts in the European countries. So that if you look at our cases, there are references to decisions of the German Constitutional Court and others. So it's a two-way process, but the English have been contributing to it. So I know the English always seem to be the exceptions and the people who are asking for opt-outs and trying to stay as far away from Europe as possible, but in reality it's quite different. The dialogue is of course also fueled by the preliminary references that are sent by the UK courts to the European Court. And I'm thinking there of Luxembourg. And there has been recent discussion about the quality of those references, because you know the English court has to ask very specifically defined legal questions to the European Court, and there have been instances where that process hasn't been done very well, because when the preliminary reference is prepared by the English court, it's usually done in discussion with the lawyers who are acting for the parties involved, so that the quality of the exchanges between the lawyers and the English courts is also a contributory factor to the quality of the reference. But I think the feeling is that generally the questions that are posed by the English courts are of a high quality. So that is contributing to progressing European law on the points that are raised. Another contribution is the art of advocacy. English lawyers always complain that if you go as a lawyer to plead at the European Court, you're only allowed 10 minutes. it's the same in French courts. If you go to a court of appeal, and you generally only have 10 minutes to make observations, which is not of course, not the way English lawyers are used to doing things. They're used to an oral procedure where the advocate plays a significant role in dealing with not just the legal questions, but also the factual side of the case and the cross-examination of witnesses. We haven't succeeded in changing the procedures at the European Court of Justice, but the contribution of that art of advocacy and the appearance by English lawyers in the European Court has probably changed the continental view, if I can put it like that, of the way cases are pleaded. Another contribution is the notion of precedent. So I think there's been I think we have contributed to perhaps a growing awareness in the European courts of the utility of precedents, the technique of distinguishing cases, things that we have talked about already. There are, just to leave the contribution of the English system, so I think we've probably said enough about that now. There are a few common features, fundamental common features that we share with the European courts and with European law. Probably the most important one is the commitment to the rule of law. And we will talk a bit more about the rule of law in a minute. Having said all of that, of course, you will have realized that there remain some very significant differences between the European system and the UK or the English system. One is the constitutional role of the courts. Second is the composition of the judiciary. Third significant difference is the procedure. The way trials and legal proceedings are conducted. And a last point, which is something that we've talked about in relation to the sources, but we'll talk about it again in a minute about judicial review, is the system of remedies. And enforcement of decisions. I told you the story about the purple-faced judge, I think. Yeah. But when I talk to French lawyers about that, their mouths drop open. You just wouldn't see a French court do anything like that. So, as I've said, there are still some very significant differences between the systems. I'd like to move on now to talk in a little bit more detail about how the law of the European Union has affected our system and how it interacts with our constitution. I've said this before, but I'll say it again. The UK is a dualist state. In other words, international law has to be implemented by national legislation. European law is, however, different. Well, I should perhaps formulate that slightly differently. I should say it's the same because we have implemented it through national legislation. But it's different because it's not really separate from domestic law. It's become part of our domestic law in a much wider sense than most international treaties. And that is something that has caused difficulties of comprehension, political difficulties in the UK since we joined. And for those of you who have studied European law, you may remember there's a case called Van Gent versus Loos. Van, V-A-N, and Gent, G-E-N-D, versus Loos, L-O-O-S. Which is a 1963 European Court case. And that says, or said, that the community, we called it the community before, of course now the European Union, but it's called the European Community, constitutes a new legal order of international law for the benefit of which the states, in other words, the member states, have limited their sovereign rights with limited fields, and the subjects of which comprise not only member states but also their nationals. I'll repeat that because I think it's important that you have that in mind for what's going to follow. So the community constitutes a new legal order of international law for the benefit of which the member states have limited their sovereign rights with limited fields, and the subjects of which comprise not only member states but also their nationals. The principle was reiterated in another case in 1964 called Costa, like the coffee, versus Enel, E-N-E-L, where the court restated the idea that the EEC treaty has created its own legal system, which has become an integral part of the legal systems of the member states, and which their courts are bound to apply. The court finished by saying that the rights and obligations arising under the treaty carry with it a permanent limitation of their sovereign rights. You want me to repeat that? Yes. Yeah. Okay, so Costa versus Enel, 1964, European Court of Justice, reiterated the idea that the EEC treaty created its own legal system, which became an integral part of the legal systems of the member states, which their courts were bound to apply. The member states have limited their sovereign rights. And the rights and obligations arising under the treaty carry with it a permanent limitation of their sovereign rights. So you will notice that those two cases were decided. Do you want me to repeat any of that? It's okay. So those two cases were decided in 1963, 1964, before the European Communities Act was passed in 1972. So that means that when we joined, when we said the treaties, etc., and the decisions of the European Court of Justice become effectively part of our legal system, the decisions of the European Court are precedents that the English courts will follow. We knew what we were taking. So since then, we have had a number of cases where the question of the interaction or the interface between European law and national law in the UK, sorry, I've lost track of the sentence. What I was trying to say was, since then there have been a number of cases where the question of interaction between European law and national law has been discussed. I think the first one that we can talk about usefully is a case called Factor Tame. And I think people were saying that I hadn't talked about Factor Tame. No? Well, Factor Tame was a case about UK fishing quotas. And the right of Spanish fishermen to obtain UK fishing quotas by registering companies in the UK. So, factor tame is about UK fishing quotas, the right of Spanish fishermen to obtain UK fishing quotas through the registration of English companies. So very concretely, what they were doing is you'd have a Spanish fisherman or fishing company, probably have one boat or a few boats, and they would register a company in England with the name of the boat or some other name. And factor tame apparently was one of the names of these companies. The concept of fishing quotas is a European concept, and the UK fishing quotas were being given to fishermen in the context of European law on fishing quotas in the European community. The UK government decided that it wanted to prevent Spanish fishermen from obtaining UK fishing quotas. So it passed through Parliament special legislation that was designed to prevent these Spanish fishermen from obtaining UK fishing quotas. The Spanish fishermen took the British government to court asking for an injunction. And remember, an injunction is a special remedy of equity. An injunction to prevent the British government from enforcing that legislation, which they said was contrary to European law. Okay so far? The question that was discussed and that was the subject of a reference to the European Court of Justice was not whether the British legislation was contrary to European law. I think everyone recognised that it was. The question was whether the English courts could prevent a government from enforcing national legislation. Now, this raised the question of the separation of powers, because as we will see in a minute, that the English courts will not generally call into question the legality of legislation passed by the Parliament. So the matter was referred to the European Court of Justice, who responded by saying, and I'll read the read the extract of the decision from the European Court. It said, community law must be interpreted as meaning that a national court which, in a case before it concerning community law, considers that the sole obstacle which precludes it from granting interim relief like relief en français. So considers that the sole obstacle which precludes it from granting interim relief is a rule of national law, must set aside that rule. Is that okay? Do you want me to repeat? Yes. Community law must be interpreted as meaning that a national court, which, in a case before it concerning community law, considers that the sole obstacle which precludes it from granting interim relief is a rule of national law, must set aside that rule. So, when the case came back to the appellate committee of the House of Lords, a decision then had to be taken by the English courts. Well, what do we do now? And the answer really was just to grant an injunction preventing the government from enforcing the legislation. So you can see that technically it's a little bit different from a court declaring that legislation is invalid. In France, you have a constitutional court that can declare legislation to be illegal, contrary to the Constitution. In this particular case, the issue was, can the court stop the government from enforcing the legislation? And the clear answer from the European Court was yes. But if you read that decision of the European Court literally, it's saying the English court should set aside the rule. In other words, set aside the legislation. So the next day, the independent daily newspaper had a headline which said, European Court rewrites the English Constitution. So in other words, the English courts were given a new power by European law to effectively prevent English legislation from being enforced where it was contrary to European law. So that's probably the first and most significant example of how European law has affected our legal system and the constitutional balance that had existed between the government, the parliament and the courts. There is a second aspect to the constitutional position of European law in our system, which is that the European Communities Act of 1972 is what we call a constitutional statute. And we'll talk about this a bit more when we look at constitutional law, but what that means is that it is a statute that has a particular constitutional status and which cannot be repealed. Cannot be repealed, abrogated if you like, by implication in a subsequent statute. So in other words, Parliament would have to legislate very clearly and very expressly to repeal a constitutional statute like the European Communities Act of 1972. The authority for that, the case that decided that, was actually a case at first instance in the High Court, but which has been approved subsequently by the Supreme Court. Case which is called Thoburn, Thoburn, T-H-O-B-U-R-N, T-H-O-B-U-R-N, Thoburn versus Sunderland District Council. That case was called the Metric Martyrs case. Metric Martyrs case. It was all about market traders who did not want to use the metric system. Of course, the metric system for us is a symbol of Europe. If you go to a pub in England, normally, I say normally, you used to ask for a pint of beer. And so we were being asked to renounce the ancient rite of asking for a pint of beer instead of asking for a litre of beer or half a litre of beer and giving up our pounds and ounces and miles and yards and all these things that we were used to in favour of these European things like kilometres and metres and so on and so forth. So that's why they were called the metric martyrs, because they didn't want to use the new measures on their markets, and they were then subject to criminal enforcement proceedings by the local district authorities who run markets. Now, the Thoburn case also decided that although the European Communities Act is a constitutional statute, it is not entrenched. In other words, a future parliament could decide to abrogate or repeal the European Communities Act. So this debate, this discussion about the constitutional status of European law is ongoing. And I think I mentioned to you last week that the European Union Act of 2011 has reiterated this idea that the 1972 European Communities Act could be repealed in the future, that European law has been integrated into our system only by virtue of an act of Parliament, which any future Parliament could undo. Now, alongside this constitutional viewpoint, is a developing body of opinion amongst academic lawyers, but also amongst members of the senior judiciary. In other words, the top judges in the country. That there are probably limits to the power of Parliament to take away fundamental rights. Now I think I'm going to just leave that point hanging in the air for you just to remember, because we'll come back to it in another way when we look at constitutional law in a few minutes, or next time, depending on how fast we go. But just before we go there, there are two things I wanted to mention. We've got 5 minutes before we break off. The first is that I mentioned just at the beginning today that one of the impacts of European law on our system was the approach to interpretation. And to cut a long story short, I will repeat what I have said before, that the English courts now use the European methods of interpretation, including the teleological system of interpretation. And that means something quite different to the way the English courts are used to interpreting national legislation. And there are four points in there, I think, about teleological interpretation. The first thing that the court would look at excuse me, is the spirit of the legislation. And when you talk about the spirit of legislation, this is something which is quite alien to the way English lawyers think about legislation usually. The spirit in the European sense means the general beliefs and common values of the peoples of Europe. So that's quite a challenge, isn't it, for a European court to work out what are the general beliefs and common values of the peoples of Europe. But it's something, of course, that the European court is used to doing and has been doing since the European project has existed. So that has been a challenge for English judges to impregnate themselves with that idea of the spirit of European legislation in whatever field of legislation it is. The second thing that they will look at is what is called the general scheme of the legislation. So that is looking more precisely at the purpose of the legislation. The third thing they will come to is the wording. And you will remember when we looked at the way English courts interpret national legislation, that's the first thing we start with, is the wording. So in the European methodology, you only get there at the third go, as it were. And the last thing that you would look at if you were interpreting teleologically is the context. how the member states would be expected to implement European law in the national context. And probably the fourth point is that the European court and the English courts, when they're looking at European legislation, would look in much more detail at the legislative history. And all this may seem a bit kind of up in the air, a bit kind of, floating up there in the legal stratosphere somewhere. But actually, it's very concrete. I have a case in the office at the moment where we are representing a British commercial agent. And a commercial agent is under French law, it's called a self-employed intermediary who represents a company to develop their business. And in the French legislation, in the European directive on commercial agents, it talks about négocier, ou conclure. Negotiate or conclude contracts. And our British commercial agent was terminated by his French principal, the mandant, who is in fact part of an American industrial group. And their lawyers are trying to argue that our client is not a commercial agent because the word negotiate means that you have to have the power to conclude contracts or significantly affect the price. And this is based on recent Cour de Cassation decisions, which seem to be adopting a very restrictive, very narrow approach to the definition of négocier or negotiate. And so we're arguing the case along a couple of lines. The first is that this is a bit the British approach. We can make a distinction because the Cour de Cassation cases appear to be what you would call a cas d'espèce. So we're trying to say the facts in our case are completely different to the ones that have been decided. But you know what it's like reading Cour de Cassation decisions. You get very little in the way of facts. It's very convoluted, very complicated to understand. I usually have to get out some ice and put it round my head when I'm reading Cour de Cassation decisions. Maybe a glass of whiskey at the end when I really haven't understood. But anyway, joking apart, we still have to face the fact that we've got these decisions which very elliptically say négocier means impacting the price. What you have to know is that very few commercial agents in reality, in practice, actually have the power to change the prices. But anyway, the second line of attack is to say, wait a minute, that the French courts have to interpret their national legislation in accordance with the purpose, the general scheme, the spirit of the directive. So we've been digging in the office, we've been doing research on what the word negotiate means in a European context. And it's actually quite difficult to find. And what we're going to do, or in the process of doing, is going back to the first European Commission proposal for the directive on commercial agents, which dates back from 1973. And of course, it's too old to be on the electronic library system of Europa. So we're having to go back and try and get copies of the original paper materials. But I think we will find, and I know, how do I know this? Because in the English materials on this, there is a report of the Law Commission, there are reports to the UK government when the introduction of the directive was being discussed in the UK, that refer to these original materials. So that just illustrates the process that you have to go through when you're trying to deal with these cases involving European concepts. Right, well, we've gone way past the break. Sorry. So just 5 minutes then, please.